Before we begin, may I remind everybody that the board has made an anonymity order in this case, that no one shall publish or reveal the name or address of the child who is the subject of these proceedings, or publish or reveal any information which will be likely to lead to the identification of the child or any member of his family in connection with these proceedings. I always read that out because, as you all know, these proceedings are live streamed, and indeed people can also go back and search the archive should they be so inclined. And so it's important that people remember that when they address their submissions to us. I also say it to remind the board. Thank you.
Lady, thank you very much. My lady, my lords, I appeal on behalf of the appellant, who I refer to as the appellant throughout for the reasons your ladyship has already forewarned us of. I appear together with Mr. Simon Callum. The respondent is represented by my learned friend, Miss Deirdre Fottrell, leading counsel, who leads Richard Castle and Ellery Jones. It's always a disappointing start to any of these appeals that we all on the front bench begin by apologising that your ladyship and my lords have been put to some inconvenience by the late production of the right version of the Patel and Mirza Authority, and I can only apologise for that. But there it is.
If that were the worst of your problems, you would not be doing too badly.
My lady, I think, thank you for that, but the whole of this case begins with a single document. It's at MS 133, or for those following in the core bundle, it's also page 133 behind the first of the tabs. And this was the application for the recognition of the paternity in the Latvian proceedings. The signature of the parties appears on the Latvian copy over the page at 134, about 4/5 of the way down. And coincidentally, we have a taste of where that signature should lead by the reference to the order over to the right-hand side of the page. Of course, that's simply a description by way of recital of the order. The order itself is found earlier in that bundle, back at pages 19 to 20. But it's the route from that signature to that order which is at the very heart of this appeal. And the question is a relatively simple one, although the answer, of course, is immensely complicated, and that is whether or not there is to be recognised a class of parent created by operation of law which this father, the appellant, can find himself within. One of the interesting features of this case is, although we have these signatures there at 134, at no stage has it ever been the case that either the appellant or the respondent has ever had to submit to any form of cross-examination or oral challenge as to what this means. And so the respondent is able to say fairly that when we allege this was procured by fraud, that has not been the finding of the court, and they're absolutely right to say so. Similarly, when the mother says this is simply the product of a mistake, we have not ever had an opportunity to challenge in respect of this. Had we had that opportunity, we would of course focused on the word paternity. The mother's case, as my lady and my lords may have read, is that she entered into this document on the basis of a mistake. It may be that the focus has not been so readily on whether it's a mistake or a deliberate fraud, because both mistake and fraud would have permitted the setting aside of this acknowledgement in the Latvian proceedings had they been within time. Questions would have been directed to the mother about what she understood by the words application on the recognition of the paternity. And that's really where the significance of this case and its general public importance is emphasised, because if the respondent's case is correct, there is now a fast route to obtaining an adoption. If one acquires the parenting role of a child from, say, a developing nation, brings that child to a jurisdiction somewhere within the European Union, Latvia, for example, and fills in acknowledgement saying, well, we are now the parents. After 2 years, on the face of it, it looks as if one has achieved a de facto and de jure adoption.
Well, whose law governs it?
Whose law would govern?
Whose law governs either that question or this question?
Yes.
Our question here is, on the face of it, what Jersey law means by parent.
Yes, indeed.
However, if parent is a question of status, there are rules in the conflict of laws as to how we determine, whose law determines a status. Now, I'm not saying that parent necessarily is a status for this purpose, but obviously legitimacy is a status for this purpose, and various other things are statuses. So
yes.
You've just made a very broad statement, but a lot would depend upon whose law governed it and which courts had jurisdiction to determine the question.
Lady, yes. And
so your interorum argument about people going all around the world to pick up babies and bypass adoption doesn't really help, does it?
I see. In which case, I wish to help, so we'll move straight away on to what we say is the case which gives the best guidance in looking at these particular matters, and that is the case of Roe, which is found within MS 1142. And this was a decision of the Court of Appeal, where for example, the case of Carl Zeiss Stiftung was considered. And we have alighted on this case as being a particularly good statement of the role of res judicata in respect of and issue estoppel in respect of children matters, even though the case is not entirely on its facts on point. It does have a substantial similarity, and both the judgments of Lord Justice Orr and of Sir Stanley Rees are very helpful, we say, in looking at this particular matter. Because, of course, one of the...
How does a case about whether a child has been accepted or treated, depending upon when the question arises, as a child of the family, for the purpose of the law of England and Wales, help us to decide whether somebody is a parent for the purpose of the law of Jersey?
The thrust of the respondent's case is that because Latvia has decided that this child is to be treated as a child of the appellant, and the appellant is therefore the parent, that is a decision which should inform Jersey as to what a parent is.
Well, did Latvia have jurisdiction to make that order?
We have some doubts about whether Latvia did.
Well, we need to know the answer to that, don't we? And
will Roe and Roe help us in relation to any issue of private international law? That is the prior question.
It will help insofar as we're really addressing the point that's raised in my learned friend's case, where they're saying that there's either a form of res judicata or issue estoppel of the type that was seen in the Carl Zeiss case, and Roe and Roe does deal with that particular issue. So it assists with that. Whether or not Latvia should have been determining the parentage of a child at all is questionable, but we say quite independently of that, there is all manner of public policy imperatives which are at play here.
Let's have some rules of law first, then we can look at public policy. Did Latvia have jurisdiction to make this order? If so, does Jersey have an obligation to recognise the order or not?
Yes. The jurisdiction in Latvia, we say, is properly founded on where the child would have been habitually resident at the time. That is not something which was the subject of a forensic challenge, because all of the court hearings that took place were in courts of cassation, where all the matters were dealt with effectively by way of submission, and specifically on the basis of whether or not the acknowledgement should be set aside.
Obviously, but if there was a challenge to jurisdiction, there's no problem about bringing that up in a court of cassation.
No, there isn't.
It's a question of law, surely.
Can we just explore with you what links there were to Latvia when the declaration of paternity was made in 2006, when the refusal to scrap it was made in 2012? Now, what is the nationality of this child?
The child is Latvian, as far as we are aware.
Right. Was the child born in Latvia?
Yes, yes, my lord.
In 2006 and 2012, was the mother domiciled in Latvia?
Yes, by domicile of origin, yes.
Was the child domiciled in Latvia?
It would seem that the child was domiciled there.
But your client was not domiciled there.
Correct, yes, my lord.
Well, on that collection of facts, does the Latvian court have jurisdiction to determine paternity?
It does look as if it does, yes, my lord.
Thank you.
The question then becomes one of the circumstances in which a determination as to paternity is undermined by it simply not being the truth. And if it's not the truth, whether or not the Jersey courts, applying their statutory obligations, and of course they are a court of statute, are able to say, well, we simply accept whatever Latvia says, rather than go on to investigate what the truth might be. And it is over that key question that there is one of the principal differences between us, with the respondent saying the biological heritage of this child is relatively unimportant, whereas we say it is the biological heritage of this child which formed the whole basis of the decision in Latvia, and that was procured either on the mother's case by way of a mistake as to what she thought she was entering into, or on the father's case by way of a fraud that was practiced on him when he was told he was the father when he was not. Either way, both of the parties to any of the issues are agreed he's not the biological father. And we say the categories then of parent which are available to the Jersey court do not include somebody who is not either married to the biological mother or is a person who has adopted the child or one of those other exceptions. He falls outside. In our case, I see we repeat twice, the category that the father falls, the alleged father falls within is an entirely new category, as he is neither the biological parent nor is he married to the biological mother. And
you say it's an entirely new category. There are plenty of places in the world which recognise what we would call de facto adoptions. There are plenty of provisions of UK law, I have no idea whether they're Jersey law or not, which provide for a person who has no biological relationship with the child to be a parent. I'm thinking of the Human Fertilisation and Embryology Act provisions, which are extremely broad scope. And that's a matter of UK law. There are other parts of the world. I mean, you made a very sweeping statement, but there are other parts of the world the parentage can be recognised in a variety of ways, irrespective of biological connection. So, it's not as...
And, my lady, all those cases where they fall outside are specifically provided for, whereas this is a new category. It's not one that's provided for within the human embryology legislation. It's not one which falls within any of those categories. The de facto situation is an interesting one.
Quite a lot of legal systems provide for acknowledgement by unmarried fathers of their paternity. This is not at all rare, and it may or may not be accurate, as a matter of fact. But the acknowledgement, if it's legally certified, is enough.
The question then becomes the basis of that acknowledgement. And
Well, the question then depends upon whether the acknowledgement can be withdrawn or overturned. And that depends on a question of jurisdiction.
Well, quite, and whether or not there is no opportunity at all, for example, for the Jersey court to say, well, that acknowledgement was obtained on a false basis, and therefore, in discharging the duties that we have under the statute, which appear to define a specific category of parents, which include people with parenting orders under the human fertilisation embryology legislation, that this particular child falls within that category. And that's not an exercise that the Jersey Court of Appeal...
In this case, the appellant had the opportunity to raise that question, and did raise that question before the court of the domicile of the mother and the child, and didn't succeed.
Well,
so having had a ruling from the court of the domicile, which is adverse, he is seeking to reopen the point in another court, another jurisdiction.
Well, the way that it is raised, and if I may come back to the question whether there's an issue estoppel in a moment, the way that it is dealt with does pay revisiting within the scope of the decision itself. And there are the two decisions. There's first begins at MS 323, which is where the single judge first dealt with the matter, and then subsequently we have the appeal decision, which begins at 330. Beginning with the first decision, which appears to inform how it is that the first court dealt with it, and if I could invite my lady and my lords to go to MS 326, we have in the penultimate paragraph at MS 326, the single judge, the first instance judge, saying this: there is no argument between the parties in the case that the plaintiff is not the biological father of the underage child. So, at that, just pausing at that point, so no requirement, we would say, to start looking at what might be corroborative evidence, such as DNA tests and so on. It goes on to say, there is an argument between the parties regarding the moment when the plaintiff has learned that he is not the biological father of the child, whether on December the 11th, 2006, when the parties applied to the registry office with the joint application on the voluntary acknowledgement of the paternity, the plaintiff knew that he was not the biological father of the child. They then, on the basis of submissions only, no oral evidence whatsoever, go on to venture their best guess as to what this issue of fact might be resolved in respect of. First of all, in the third paragraph down on MS 327, they complain about the lack of DNA, or the judge there complains about the lack of DNA tests, a point that we say is a red herring. The court asked repeatedly during the sitting of the court whether the plaintiff's party would like to set up the expert examination for the case, though as the representative of the plaintiff had indicated prior to the completion of the case examination, there is no argument in the case on the aforementioned, and the expert examination is not required. And as the Jersey Court of Appeal rightly describes this, this is no more than a suggestion. The court doesn't make a direction that's not complied with. And it has to be right that the parties did not obtain a direction for DNA tests in circumstances where the truth was known. There might have been a dispute about how that truth was revealed, but the truth itself was not in issue at all.
It wasn't an issue between the parties, but from the court's point of view, there was a problem about that. These two people had pitched up in 2006 and signed something saying he was the father. They're now pitching up in 2012 saying he's not the father. And so the Latvian court says, what are we supposed to do about this? What do we believe? What they said first or what they said second?
Yeah, when were they telling lies?
Well,
And you know, DNA testing, they say, would have solved all this. But there was no DNA testing. And so the first of the three grounds for the dismissal of your application to rescind the declaration is you haven't persuaded us that you are not the biological father.
yes,
So when you come to this court and say, it's all agreed, that where my client is not the biological father, there is a problem about that, because the Latvian court hasn't bought that argument.
I would agree with your lordship if it had been the case that the Latvian court had said, we therefore direct DNA tests, and there are many cases in this jurisdiction, in the English jurisdiction, where the failure to comply with a direction for DNA tests is taken as overwhelming evidence that the DNA tests would prove the position adverse to the party who does not wish to submit to those tests. But that's not what the Latvian court did. The Latvian court never goes beyond a suggestion of the DNA test. There's no intimation that we can see that the Latvian court is concerned to disturb what the two parties themselves are saying as to the biological heritage of this child. And that's why I went to the earlier paragraph first off, because it does say there is no argument between the parties in the case that the plaintiff is not the biological father of the underage child.
But, I mean, isn't the Latvian law concerned with the interests of the child? The child hadn't admitted that. And might it not be said that it's implicit in your client's own fraud case that it's at least a possibility of biological connection?
Yes, it is implicit within that. He has always said, and he says again, and one of the matters that I've taken specific instructions on is if the board is of the view that he should even now be directed to undergo DNA tests, he is happy to do so, and he has indicated throughout that he would undergo DNA tests. The only reason why he's not undertaken the DNA tests is because his reading of the Latvian court is that as they were not directing them, and indeed the child who had the orphanage service acting in effect for the child were not making an application for those tests either, that the issue had been resolved. It had been not just no argument between the appellant and respondent, but no argument at all.
I don't think that's an accurate way of analysing this judgment which you've drawn to our attention. We've still got page 327 open in front of us, and the second full paragraph, the final sentence. Thus, while observing one of the fundamental rules of the civil procedure, the principle of the free actions by the parties or the permissiveness, the expert examination was not set up in the case. Isn't the judge there saying, it's a matter for him. He's got to come along and prove that he's not the biological father. And we're not satisfied. He could have asked for DNA testing. We might have made a direction. Then it would all be sorted out. But he hasn't. It's up to him.
In a case where all of the parties before the court, which includes the representatives from the orphanage, are saying there is no dispute, he is not the biological father, then there is, we would respectfully say, not the necessity for there to be the DNA test. And if there is, if the court is of the view that there is that necessity, then it is open to the court to do more than suggest. The court can direct. Indeed, one would imagine that if, for example, on behalf of the child, as as my Lord Sales was indicating, if the child's own welfare demanded this, then that's an application that could be made there. And it remains the case that a court, including, we would say, this one, could direct a DNA test, and at any stage the appellant would agree to that. The difficulty...
Well, we don't go fishing around for further evidence. It's served up on a plate.
Well,
We see what's served.
Well, he was very much of the view, supported by all the other contestants in the litigation, that he didn't need to go fishing for further evidence. He had enough evidence to get home. There is no contrary evidence at all to suggest that he is anything other than the parent in terms of what the parties to this litigation themselves are actually saying.
Well, there's the 2006 declaration.
Well, there's the, sorry, in respect to the 2011 proceedings. The 2006 declaration is a document which he's explained, and which both explanations give rise to it being potentially invalid. If it was the case that DNA tests were going to be so critical, though, either the representatives of the child or the court could have said, well, this should be provided. More importantly still, we say, the Jersey court, when it comes to exercise its own discretion, faced with the same dispute. And I hope it's not unnecessarily emotive to describe it in terms of slavishly following, but rather than simply following what the Latvian court have decided, they are entitled to look at what the Latvian court actually did. And if they think it is critical, the Jersey court also can direct that there be DNA tests. But assuming that the DNA tests are going to establish that which is an agreed fact between the appellant and the respondent, we then have the question of how could that acknowledgement possibly stand? And yet all of this turns on no more than a Court of Cassation hearing submissions from the advocates on both sides, and then that being wholly determinative of the separate Jersey proceedings. And the real problem with this is we then end up with a lacuna between what is the known truth and what is the basis of the decision. My learned friends, understandably, take issue with us when we say the whole basis of the Latvian court is that the father is the biological parent, and they're referring in particular to the other two grounds that are referred to in the Latvian Court of Appeal and also in this first instance decision. But the whole basis is not that. It's, as my Lord rightly said, it is the 2006 acknowledgement, and the acknowledgement in 2006 has its genesis wholly within the idea that it is the appellant and the appellant alone who is the biological father. When he prepares his statement for the purpose of the 2006 rectification, it's solely on the basis that he is the biological father, on no other basis at all. It's not, as my lady reminds us, is available in some jurisdictions where there can be an acknowledgement of a non-biological parent. That's not what...
Well, there can be an acknowledgement irrespective of whether the truth is known, because until quite recently, it was not possible to know the truth.
Right.
It historically has always been the case that motherhood is apparent, but fatherhood is a presumption. So it is well known that a substantial proportion of children whose legal father was X are not actually the biological children of X.
And my lady, the problem does still exist, although to a much, much smaller degree, because there is still the opportunity for people to obtain false DNA in order to promote a particular view. There are no limits to human ingenuity when it comes to fraud, and particularly when it has the huge financial consequences which a determination of paternity can have, and indeed do have in this particular case, particularly with the law of Jersey in respect of heirship. So, starting from the position that the acknowledgement itself is born of a determination of the biological parentage, one would have thought that if the court in Latvia felt that the DNA issue was of such fundamental significance, the court in Latvia could have directed it, but it didn't need to in circumstances where the parties were agreed. And that raises a second issue which comes up within the Latvian judgment, and that is to do with their appraisal of when it was that the appellant first knew that he was indeed not the biological father. His case is that he first knew on the 9th of March of 2011, when the matter was disclosed in the court in Jersey. The basis upon which that is rejected, again, should have been unsettling to a Jersey court that felt it had to follow the decision of Latvia. The judge at first instance deals with it very much in terms of possibilities, arguments, again with a complete absence of there being any oral evidence from the parties themselves. At the bottom of MS 327, they deal with it in these terms. The court establishes that the plaintiff could have known since the birth of the child that the child had not originated from him. Well, that's a fairly weak basis that he could have, particularly as people, fathers in this position, may well wish to be blind to truths they don't want to hear. They say this: the parties have frequent arguments, got separated, and then resumed their cohabitation together again. In the statement of claim, the plaintiff has indicated that he met the respondent on the 10th of October 2000. Afterwards, he spoke of January 2003, when the defendant informed him that she is pregnant. And then they deal with assumptions from general knowledge. Though having assumed as a fact of general knowledge the length of the female pregnancy, the plaintiff should have spoken about the relationship between the parties in October or November of 2002, which would not have excluded the possibility that the plaintiff is the biological father of the child. And they then develop the argument, say, so in 2006 he should have been challenging a paternity that he wished to believe was his own. And that's it. It's very thin gruel upon which to feed the idea that the father knew at some time much earlier than 2011, possibly 2006, possibly even as early as 2002 during the pregnancy itself.
But perhaps I got muddled. I thought in 2014, in the Jersey proceedings before the registrar, your client's advocate was saying there were no sexual relations between the parties until 2005. Was he not putting that?
He did put that, and my lord, if we could turn to that.
Is it at 62 in bundle 1?
262.
What, no, 62 in bundle 1.
So sorry, 62. Indeed.
Paragraph 5, third line. The father's advocate put it to the mother in cross-examination. The relationship didn't commence in 2000, but rather in 2005. Now, correct me if I'm wrong, this child was born sometime in 2002, 3, something like that?
Yes.
On that basis, he knew perfectly well all along that he wouldn't be the father.
My lord, if we could turn to the transcript itself, which is a 212.
Yes.
Because all of the evidence, and before coming to the detail of the transcript, all of the evidence adduced by the father is consistently that he was in a relationship from so all of his own statements say he was in a relationship from 2000, October 2000. And the way that it's raised is at 212 we have after an adjournment, we have Advocate Goulburn, who is cross-examining the respondent, and at the bottom of 212 it says, and if you turn to paragraph 7, which is page 12 of the bundle, paragraph at the top, and you say your relationship with the appellant started October 2000. Yes. Well, that's not strictly accurate, is it? You met with him in October 2000. And then the answer of the mother is, we met and the relationship started. And then the advocate puts to her, the relationship didn't start until either late 2005 or 2006 after the death of his wife. Did it? Question mark. And she says, no, the relationship started exactly when we met on the third day. We already went to Holland for a trip, and since then we were meeting and having a permanent relationship. And then it's put to her, in cases, that's not correct. The relationship didn't start until much later than that. And then that's the answer which is put there. And
so the question is, on your client's case, no sexual relations until years after the birth of this child, how can he possibly say that he only discovered he wasn't the father in 2011?
Well, that wasn't his case. His case, in all of his statements...
What wasn't his case? What the advocate was saying?
Yes.
So the advocate got it wrong?
I have not been able to get an explanation as to why the advocate was saying that, but I do know that in every statement that the appellant has produced, the appellant has said it was in 2000. And there's a good illustration of that at 324 in the single judge's decision, when the single judge is reviewing matters, in the...
Yeah, that's what he says.
Yes. When where the single judge refers to what the appellant is saying there, and that is in 2012, March 2012. Sorry? Yes, and he's referring to the claim statement which the appellant has produced, and it's the last two paragraphs where it's first of all set out that the father says that he found out in 2011 that he wasn't the father, and then we have the defendant did not acknowledge the claim during the sitting of the court, having additionally noted that she met the plaintiff in January of 2003 when she was already in the third month of pregnancy, that she had told the child is not his, pregnancy occurred in October.
Has it ever been said until 6 minutes ago that Advocate Goulburn had no instructions to put what she did in 2014?
It has been said that Advocate Goulburn's questions to the respondent were inconsistent with what the father has said was his case.
Oh, undoubtedly. I mean, there's real complete confusion. You find a whole lot of inconsistent things. This is one of the problems the Latvian court had previously had. But it's never been said that that was contrary to his instructions at the time, has it, Mr. Todd?
At this time, I don't think it's said that is contrary to instructions. I don't think it's a case that the appellant gets up and says it, but certainly my instructions are that what was said by Advocate Goulburn was not what the father believed to be the case. And the father praised and made his representations to the court on the other occasions, such as the statement that was put before the court, and indeed the claim which he issued in the Latvian proceedings, which would have been available at the time of this cross-examination of the respondent, where one imagines that it would have been an easy matter for them to stand up and say, well, hold on, in the Latvian proceedings, you've accepted the relationship went back long before 2005.
Yes.
So when I say it's inexplicable because I've not had an opportunity to speak to Advocate Goulburn. I can only go on the basis of my instructions, and my instructions are that it was a question that was inconsistent with what the father had always believed to be the position.
Thank you very much.
And I don't think I need to go much further than that. The key question, though, that we come back to is whether or not the determination within Latvia should be determinative of whether or not this is a child in Jersey as well. And when the matter came on for an appeal, with the appeal decision begins at MS 330, the court again proceeded on the basis, and this is now at MS 332, where they come to what is headed the reasoned part, where they considered the explanations that the participants in the case, together with all the files in the case, and they considered their law section 432, and then in the fourth paragraph up, the Board of the Courts of Civil Cases agrees to the conclusion of the first instance court that there is no argument that the plaintiff is not the biological father of the son the defendant bore back in 2003. So once again, we say in circumstances where the court appears to be accepting that there is no dispute that the basis of that acknowledgement, i.e. the biology of the child, is in dispute, then there was no need for there to be a further investigation. They then deal with the 2-year limitation period. This is while taking into account the limitation, the 2-year deadline to challenge the recognition of the paternity as stipulated by the section 156 of the civil law, the issue on the time when the plaintiff has learned about this remains essential. And just pausing there, this emphasises once again that whatever concerns my Lord Sales may have had about what is in the best interests of the child and whether or not it would be best for the child to advocate that this man is his biological father and therefore he might want DNA tests, that's not what happened. After the argument, it seemed to be proceeding on the basis of that there is no argument that he is not the biological son of the appellant. So we then come to the 2-year issue. And again, the Jersey court, in looking at what is decided, is more concerned with what we would describe as an issue estoppel than a point of res judicata, because the question before the Jersey court is whether or not financial provision should be made. In looking at whether or not an issue estoppel arises from this decision, the Jersey court should, we respectfully say, have looked at what actually came to pass within the Latvian proceedings. And what comes to pass is that the father indicates in his statement, which is described as a claim in the third paragraph up on 332, that he only knew on the 9th of March 2011, when the defendant disclosed to him in the court of Jersey that he is not the biological father of the child who had been registered. And then we have the counter assertions from the mother, who also doesn't give evidence. Meanwhile, it ensues from the explanations of the defendant that right since the birth of the child, which means at the time of the filing of the application and the recognition of the paternity as well, the plaintiff knew that he is not the biological father of the son. though having wished to start a family with the defendant, he chose to legally register himself as the father of the defendant's child. And her explanation for that, we know, is that she believed she was mistaken and that what she was doing was a process of adoption. Well, mistake would also, of course, allow for the setting aside of the acknowledgement. The case is then said to be supported by statements. It's described as evidence, the bottom part. The files in the case show that the aforementioned explanations of the defendant are corroborated by the evidence of the witnesses questioned by the first court, and then two names are given. The engagement contract the parties entered into on a date in December, on 3rd December 2005, unambiguously serves as evidence as the parties' intent to start the family. Well, again, this is a very thin basis for saying so, and then we have a repeat in the paragraph immediately below on 333, which is, in effect, well, he should have been alive to these questions back in December of 2006 when he voluntarily recognised an acknowledgement of a child he believed to be his own. And it does import a degree of cynicism as to the extent to which a father who wishes to marry, or a putative father who wishes to marry a lady, is going to say to her, back in 2006, when she says, "This is your child," that, of course, is his case, that when she says to him, "This is your child," he says, "Well, I would like some DNA tests." It is not a suggestion which is going to be good for good relations at the start of a planned marriage. And, of course, we know as late as December of 2005, they are planning exactly that and talking about entering into that and so on. The supposition of the appellate court in Latvia continues in the third line at 333 of that paragraph. Furthermore, the representative of the plaintiff failed to explain to the court as to what put off the plaintiff from the verification of this child's filiation from prior to the filing of the application on the recognition of paternity with the registry office, because having known the defendant has had close relationship with another man as well, and the child has already had another father registered. Such a verification would have been simply logical if the appellant wished to register himself as a father to a child, this child surely being the one who has descended from him. And again, it imports the idea that this engaged couple on the verge of being married, really, he should have been saying, "I want DNA tests." And that is the quality of the evidence. There's no transcript of where the father is challenged about his knowledge, or indeed the mother is challenged about her knowledge, where she's able to say, well, this is the occasion where I told him. Here's a letter where we referred to what the truth was. Here are some emails, all the sorts of evidence one might expect to see. None of it is present. And coupled with the fact that they do seem to be working on the basis that he is not the biological father, and that he has filled in the form as if he was on the basis of, he says, a representation, it ought to have been, at the very least, unsettling to the Jersey court in the discharge of its statutory duty as to discovering what a parent was, rather than simply saying, well, we have to accept what the Latvian court has said, even if that might fly in the face of what is plainly the truth. But of course, part of what they are accepting from the Latvian court is the father is not the biological parent. So that then raises the question of whether or not there can be a category of parent which has not been the subject of any parenting order under the fertilisation and embryology legislation, has not been the subject of an adoption, not married to the mother, and not been recognised as the biological parent. And that then raises the question of the court going outside or creating a new ground.
No, the court isn't doing any of those things. The court is saying the Latvian court had jurisdiction in this matter. The Latvian court has determined the matter. We would need to have some very good reason for overturning that.
Well, lady, yes, and they did have a very good reason, which they didn't take, and that very good reason was the whole premise of the Latvian proceedings was on the basis of an untruth. It was on the basis of a lie.
But the Latvian courts were content because Latvian law says if you've acknowledged your paternity of a child in a formal way, which is recognised by Latvian law, you can challenge that, but only within 2 years, because otherwise it will be bad for the child. That's what Latvian law says.
Yes, that approach by the Latvian law is one which we would say in the vast majority of cases the Jersey court would be following and they would be giving recognition to it. But in a case where...
Well, on what basis could the Jersey court fail to accept the determination of the court which you have accepted had jurisdiction in the matter?
Well, there are two bases. One of them is that jurisdictional point, but on a slightly different and a finer point, and the second is on public policy. On the jurisdictional basis, the jurisdiction which the Latvian court is exercising on the basis that this is genuinely this is the 2006 jurisdiction. This is genuinely the biological child of the father. And that is the jurisdiction which they purport to exercise. My love friends have referred to a number of cases on status that deal with decree absolute, and they've said, well, you wouldn't be allowed to raise, by way of an example, if there had been a dispute about an unreasonable behaviour petition, you wouldn't be allowed to go back and say, well, that unreasonable behaviour was not validly made.
But I mean, surely the jurisdiction the Latvian court is exercising is jurisdiction to determine the father's application to have rectification of the birth register, well, not the original filing of the application.
Well, all they do in 2011 is say we're not going to rectify the position. So the paternity comes from 2006. It's not that in 2012 there is a declaration that he is the parent. There's simply a refusal to not reverse 2006.
Yes, but you were addressing us about what jurisdiction the Latvian court was exercising. And what I'm putting to you is a question, isn't it right, analytically, to say that the jurisdiction that they're exercising in 2011 is that on the to determine the application of your client to have the birth register rectified?
My lord, it is, but it's akin to adopting my learned friend's example of a decree absolute. It's no more than if someone applies to set aside a decree absolute on the basis of there was a want of jurisdiction. And where this case falls is between those cases where an estoppel would arise because there is for example, a disputed issue of fact on an unreasonable behaviour petition, as opposed to there was no habitual residence, so there would have been no jurisdiction at all. And what we say is, where there had been, to adopt the case like Rapisada, where there had been no marriage at all, that would also fall within the character of a jurisdictional question. And here, that jurisdictional basis is, was this child biologically the father's? And that's a 2006 matter. So an application to set aside a decree absolute would be akin to a 2011 proceedings, but the original determination would be akin to 2006. And we say, jurisdictionally, it's not established where the parties, either through collusion, through mistake, or through fraud, have presented a false basis. And the comparable that we adopt is it's like obtaining a petition for divorce when there had not been a marriage at all. And both the parties knew there had not been a marriage at all. And in those circumstances, we say that is one of those jurisdictional exceptions that's referred to in, for example, the Raposada case. I don't know if it's convenient just to look at that at this time. It's in MS 1089, and the reference in particular is at 1097, where there is a summary by the then president of the Family Division in Raposada, where he was concerned in the Raposada case. It's, I say, MS 1089. This is one of the authorities referred to on the respondent's case. This was a case where there had been difficulties in obtaining divorces in the European Union, and something in the order of 180 divorce petitions have been presented to various English county courts, spread throughout the whole country. I think it's said in the course of the report from Aldershot to York. And all of those proceeded on a false jurisdictional basis, simply because that was a much better way of getting on with the divorce than relying on the relatively inefficient processes that were available in the European Union. Sorry, within the continental European Union. And the president examined the authorities going back to Beta and Beta, and we can take all those authorities together because they're helpfully quoted by the president from MS 1096, where at paragraph 18, the president says, perhaps paragraph 17 is a better intro. I've said that the Queen's Proctor's case is based on an allegation of fraud, and that if fraud is established, any decree, whether nihil or absolute, will be void. What is meant by fraud in this context? What has to be established if a decree is to be held
Sorry,
void?
which paragraph are you reading from?
I'm so sorry, my lady, it's paragraph 17.
I was trying to get to grips with the circumstances of this case before.
I'm so sorry. I should have spent more time on that. It was a group of 180 divorce petitions which the Queen's Proctor had referred to the family court for them to be set aside on the basis that they had been procured on a false basis.
And were they set aside?
They were. Yes, my lady. And
so the reasoning is that fraud as to jurisdiction renders void.
Yes, my lady. Yes. The President described this as being a fraud on an industrial scale, as they were applied all over the country. And he then analysed what was meant by fraud and the distinction with those cases where fraud might not be apt. So at paragraph 17, he asks the question, and then he analyses two decisions of a previous president of the Family Division, Sir Stephen Brown, the first in Callaghan, and the second, the well-known Moynihan case, formerly Colin Moynihan MP. In paragraph 19, he deals with the Callaghan case where he says, the husband sought to set aside a decree absolute obtained on the petition of his now deceased wife on the ground of fraud. The alleged fraud was that the petitioner had falsely sworn in her affidavit verifying the petition that the marriage had broken down irretrievably and that the parties had been living apart for at least 2 years. In fact, so he now alleged, the marriage had not broken down and the parties weren't remained living together until the petitioner's death. And the then President summarised matters as follows. In the case of the divorce proceedings presently under consideration, there was no want of jurisdictional procedural irregularity of any kind. The proceedings were in all respects properly constituted. The alleged defect now sought to be relied on by the plaintiff relates entirely to the nature and quality of the evidence before the court. And so, my lady and my lords, that was the parallel example I gave of, say, an unreasonable behaviour petition. he then goes on in paragraph 22 at 1097, refers to the analysis of the authorities, including the Bater case, and the quotation from Bater at paragraph 22 saves us turning up this part of the authorities, where Sir Stephen summarises it in these terms. As was pointed out in Bater's case, a decree absolute affects status and is equivalent to a judgment in rem. It is in the public interest that a decree absolute should be unimpeachable where no question arises as to the jurisdiction of the court pronouncing it, or as to the procedural regularity which led to its being made. In this case, the plaintiff was a full consenting party to the divorce proceedings. There was no want of jurisdiction in the court which pronounced the decree, and no procedural irregularity. Both the plaintiff himself, by his action in consenting to the decree, and the world at large recognised the decree during all the subsequent years which passed until the death of the wife. I have no doubt that this decree was validly made absolute, and that this should stand against all the world. It's not open to him in this court to seek to challenge the validity and binding effect of the decree absolute. And then we come to the Grabman decision. On the assumed facts on which Sir Stephen decided the case, the fraud relied on was perjury. And just pausing there, that's not what we say here. It's not a perjury within the conduct proceedings. It's the very basis of the jurisdiction at all. Going back to the distinction I drew at 7 above, between jurisdiction to entertain the petition and jurisdiction to grant a decree, the perjury in Callaghan went only to the latter, for it concerned the facts required to satisfy the requirements of Section 1 of the Matrimonial Causes Act 1973. From this I can, I think, properly draw two conclusions as to what it was that Sir Stephen decided in Callaghan. First, that perjury, without more, does not suffice to make a decree absolute void on the ground of fraud. And second, that perjury which goes only to jurisdiction to grant a decree and not jurisdiction to entertain the petition, likewise, does not, without more, suffice to make a decree absolute.
That's using jurisdiction in two different senses.
It is, Ms. Mulledy. It is. And
I mean, one understands the distinction, but
yes, it is.
it's a misuse of the word jurisdiction in the jurisdiction to grant a decree.
Yes.
But we understand the distinction that
Quite. And the distinction that we would make here is, again, it is something fundamental that goes to the jurisdiction itself. When this child, to take a slightly absurd example, if the child had been a complete stranger to both the parties, but they had somehow managed to procure a birth certificate, something which might happen in respect of one of those cases one sees where the child has come from a developing nation where money has exchanged hands and the parties now wish to fraudulently present to the world that they are the biological parents of a child, that they're not the biological parent of the child of, then it's the jurisdiction itself that will be called into question if that is something which is then impugned on that basis. And we say that would hold true, not just in the case of fraud, but also in the case of a mistake. It would also obviously hold true in a case of collusion, where the parties have got together in order to try and present to the world a position which was patently false.
Is there any authority that a mistake negates jurisdiction?
Well, all the authorities that are relied on by my learned friends are to do with the decree absolute, and a mistake as to jurisdiction is going to be rare, one imagines, and certainly not been able to find authority that deals with mistake. I mention mistake because that's one of the exceptions it's referred to in the Latvian legislation as a basis for impugning an acknowledgement, and really almost by way of completeness. Here, there's no mistake, even on the mother's case, that the father is not the biological father. And yet the acknowledgement proceeds on the basis of, as it says on its top line, paternity. And that is plainly a false basis. And
paternity is one of those words that it could be an acknowledgement of legal paternity, which it clearly was. It could be an acknowledgement of biological paternity, which it may or may not have been. That's an evidential question. I don't mean an evidential question as to whether or not he was biologically the father, but whether or not he was acknowledging that he was biologically the father. But just to say paternity doesn't answer that question.
Well, my lady, it does in the context of West's application, 2006. Sorry, my lady. It does in the context of this particular case. I very much take on board your ladyship's point about paternity gives rise to all manner of circumstances. One thinks of many examples of patrician behaviour that exist outside entirely of this sort of setting. But in this particular case, we have the advantage reference of what it was that the father said at the time of the 2006, which is in MS 178. Which we know then formed the basis of that paternity, and it's expressed to be supported by the mother at that time. And it's very much the narrower definition. And we see at the bottom of 178 in the penultimate paragraph, where it says, "I fully acknowledge that is my son, and I am ready and willing to undertake the responsibility for him as well as all the duties of the parent arising from the law. And therefore I believe the current record of his father is to be made void, and me should be filed as the father with the birth certificate of him." And then we come to the important part. The paternity, the father's legal relationship with the child, means the social and legal recognition of the relations between the child and the father. The biological paternity is the medical issue, while the purpose of the legal paternity is to reach a balance between the biological truth, which reflects the biological and genetic paternity, and the social relations of the parents and the child, which relate to the person who is living with the child and takes care of him. I'm just going to skip over, I appreciate there's some important material in the next three paragraphs, but I'm going to skip over to MS 179. The fourth paragraph there, he then says, "I believe it is my duty to file this claim statement on the determination of the paternity, as I am the biological father of the child and plan to marry the child's mother and raise our child together." The defendant would verify these facts with the court as well.
Thank you. Mr. Todd, can I remind you of the anonymity order?
I'm sorry if I let slip.
You have.
I apologise. I'm so sorry. I've been trying to
Well,
keep it in mind.
I'm reminding you.
Thank you, my lady. The point is then emphasised in the subsequent paragraph, where he goes on to say that he knows that someone else.
You can invite us if you want to read the paragraphs you wish to refer to, and that will protect you from such slippage as has been brought to your attention.
Lord, I'm grateful. My Lord, the next paragraph emphasises the point we've said earlier. And the reason why I say it emphasises the point earlier, again picking up on my lady's point, is if it was to be a social or psychological parentage only, there was no need to displace the person referred to in this next paragraph. They could both have been social and psychological parents, but only one person could be the biological father.
Mm-hmm.
In the prayer at the bottom of 179, there is then the contest in the first paragraph, which must be on the basis, again, of a contest as to biological paternity. So the whole basis of this jurisdiction is biological paternity. If that is false, and the cases where that's going to happen are mercifully likely to be rare, but if it is false, it does represent one of those points of departure where the court in Jersey should investigate the matter further with a view to determining whether or not the particular appellant here falls within the categories of parent that are conventionally understood to apply to either in England, Schedule 1, or its equivalent in Jersey. And I referred to the English equivalent simply because that's where the authorities are principally to be found. And in considering that, it is almost a trite supposition of law that when it comes to paternity or affiliation proceedings, it's not the case that an estoppel, or rather a raised judicata, as that particular form of estoppel, arises. It's always potentially open to be reviewed. And that simply must be right, because in the majority of cases, and particularly those that my learned friends have so skillfully referred to, are cases that deal with status where there are really two people involved. They are the husband and wife situation where there is a degree absolute, or they are the situation where there is the clarity and, of course, the investigative process which accompanies it that's found within the adoption process. Here, there are more than two wholly innocent parties who are very substantially affected by this untruth. The first, of course, is the child himself. There are all manner of effects that apply. He is, for example, deprived of any heirship if his true biological father is in a regime of forced heirship, as indeed the appellant is. If he is in a regime of forced heirship, then he can't inherit, because that is not the finding. There are more mundane examples too. If he discovers he has a particular illness, and that one of the explanations might be that that is genetic, he's deprived of the knowledge of being able to pursue that. And as is referred to in some of the cases that deal with probate matters, it's also potentially consequential to his own children. But the same is also true of the genuine biological parent. The biological father there is someone who has a right to a family life, who has a right to know about his own child, and yet it would seem that he has largely been excluded in certainly Jersey court terms without a great deal of input. Certainly it is hard to find any involvement by him in the case. And there's another point which is allied to that, and that is in respect to the United Nations rights of the child, which is at MS 699, and it's more than just a pious hope of what there might be. It is a fundamental right of a child, and we would say also by necessary implication also of the biological father too. And it's, as I say, it's MS 699, and this is from the United Nations Convention on the Rights of a Child, and it's Article 7. And it's paragraph 1 of Article 7, the child shall be registered immediately after birth and shall have the right from birth to a name, the right to acquire a nationality, and as far as possible, the right to know and be cared for by his or her parents. The first of those rights is the right to a name. This child lost his name in 2006. And that was one of the matters that was obtained either by a fraud or a misunderstanding on the part of an improbable misunderstanding on the part of the mother that she thought she was going through an adoption. The child lost that. The second is textually more difficult to explain, but we say when taken with the name as well is clearer, and that is the right to know and be cared for by his or her parents. Well, it must be fundamental to the right to know your parents, to know who they are. This child is deprived entirely of that opportunity by this decision of the court.
I wonder about that, because presumably your parent will be determined by the relevant national law. You're assuming you have to read into Article 7, before parents, the word biological, and it isn't there.
We would suggest that would, by its lack of limitations, certainly include biological parents on any view. So it might include other parents as well, but it must include biological parents. Biological parents, if there is any hierarchy within parents, I'm not suggesting there is one, biological parents must certainly be at the centre of any Venn diagram that involves a definition of parents. So, yes, if my lord is saying he should have the right to know other people who are involved in his parenting, then we would agree with that. But fundamentally, he must also have the right to know whoever his biological parents are. And yet this biological father is cut out, and the child is in that position. And indeed, it's also axiomatic in the context of Article 2 at 698, where the states are enjoined to respect and ensure the rights set forth in the present convention to each child within their jurisdiction without discrimination of any kind. They respect the child or his or her parents. And as part of the non-discriminatory provision is also having regard for the ethnic or social origin. Well, the origin again must be a reference to biology, not just on the mother's side, but on the father's side as well. It's in respect to that too. The attempts at looking at what is meant by parent, which is an exercise we say that the Jersey court did not ultimately undertake, are born of a wealth of authority which seems to establish, we say cogently, that the class of those within parent has already been prescribed by Parliament and should not be extended to social or psychological parents at this stage. It may well be that a time comes where that's appropriate, but that is not where we are now. That would be to invite claims against, for example, step-parents. I appreciate my learned friends don't argue for that and expressly say they're not seeking for the extension of children to include social or psychological parents, but that is a potential effect of a court working on the basis which is known to be wrong, and we say procured in a way which is false. And there are a number of authorities which, if I may take your ladyship and my lords too, the first of them is the J&J case, which is MS 996. And that was a case involving a transfer of property order, where if the respondent fell within the definition of a parent under Schedule 1, then in accordance with a case called K&K, the court was entitled to transfer property for the benefit of a child. And this was a decision of Miss Justice Easton in 1992. And he specifically referred there to the word parent as is partially defined within Schedule 1, and just for my lady and my lord's note, that's in MS 661. I'm not proposing we turn it up at the moment because it is repeated within the law report itself. But the learned judge in that case at MS 998 dealt with the case in this way. It is accepted, at 998, and it is the first full paragraph, so about halfway down the page. It is accepted by the respondent that if he falls within Schedule 1, then the local authority tenancy is property, and so it can be transferred. And then, so the critical question is parent. And then at page 999, on what is the third complete paragraph, the question which arises is whether the respondent, by any stretch of the imagination, could be properly described as a parent of the daughter. And just pausing there, the daughter who's referred to is not his biological daughter, but is a girl who the mother had shared a home with him in respect of, and in respect of which she was seeking a transfer of the property. I repeat that he is not the father of the child, and that he has never lawfully been the stepfather of the child. The highest it can be put is that he has lived with the daughter's mother for a number of years, and he has regarded, until he was ordered out of the property, the daughter as a member of the household. Under the plain meaning of the word parent, I am satisfied, notwithstanding the production of the appropriate page in the shorter Oxford Dictionary relating to parent, that by no stretch of the imagination can meaning of that word he would have to be the father of the child, just as the applicant is the mother of the child. Can he be brought in as a result of the interpretation paragraph, paragraph 16? There the word parent is extended so as to embrace a stepfather who has treated a child as a child of the family. It reads, parent includes any party to a marriage. So there has got to be a marriage, whether or not subsisting, in relation to whom the child concerned is a child of the family. That is to say, not his child, but he is the stepfather who has treated the child as a child of the family. Had the respondent ever married the mother, then clearly he would have fallen within that definition. But he never did, and he clearly is not within that definition. It is also of interest to note that although the parent includes the stepfather who has treated a child as a child of the family, Parliament has not extended the liability of such person under paragraph 2, for example, where the application is for financial relief for a person over 18, nor to paragraph 15, which is where a local authority may make contributions towards the cost of accommodation and maintenance of a child. One comes back then and looks at Schedule 1, paragraph 4.2, and the words, in deciding whether to exercise his powers under paragraph 1 against a person who is not the mother or father of the child, and if so, in what manner the court shall in addition have regard to, and then refers to various matters. And he holds that that kind of step-parental relationship, non-biological, is one which does not give rise to a claim under Schedule 1, which again begs the question that if the Jersey court thought it was subject to an issue estoppel, what was the issue that the court in Latvia actually decided? Because it does look very much on its face as if it decided that this man, going beyond the labels of parent, what he actually was a non-biological step-parent. Well, non-biological step-parents, if that was the finding of the Latvian court, and it does look as if there's some support for that, are not people who are entitled to relief in Jersey under the Jersey statute. And that's a point which is made again in a number of authorities. And may I give my lady and my lords simply the reference to the next one, because there are a number which repeat the same point. The next one is the M case, Re-M Child Support Act Parentage, 1997, 2FLR, which is a MS 1019. And helpful to go to, because it's safe to go into another case. So the case of Re-M Child Support Act parentage, the decision there of Mrs. Justice Bracewell begins with a comment which I'm sure gave my learned friends much encouragement, which is at MS 1021. Well, it started by giving much encouragement, but it's then lost. At MS 1021, in the penultimate paragraph, sorry, I should have explained, this is a case which concerned an application made by the Secretary of State in respect of child support under Section 27 of the Child Support Act 1991 for the purposes of determining that a child was a biological child and that therefore the parent of that child that was biologically his should be paying child support. And at 1021 in the penultimate paragraph they say this: by reason of Mr. M not being the biological father, he can only become the father by operation of law, which is the fundamental point which my learned friends rely on. But then it goes on to develop that over the following paragraphs. It is contended on behalf of the Child Support Agency that Mr. M is to be deemed the father of the child concerned and a parent within the meaning of the 1991 Act by reason of the doctrine of estoppel. And this was, read on. The Child Support Agency is forced into the argument because it is conceded that the Law Commission, in the report on family law illegitimacy, which was laid before Parliament in order to be printed on the 20th December 1982, correctly set out the law prevailing at the date of the birth of each of the children, which reads as follows. A child conceived as a result of artificial insemination of the mother with sperm provided by a third-party donor is, as the law now stands, illegitimate. It is immaterial that the mother's husband has consented to the insemination. The status of the child is in law the same as that of a child conceived in adultery. Likewise, the donor, not the mother's husband, is the legal father of an artificial insemination by donor child. And then it said, the Child Support Agency seek to add to that definition by arguing that in circumstances in which the husband has consented to the impregnation of the mother by AID, that he is stopped from denying that he is the parent of the child within the meaning of the Child Support Act. That is the only issue which arises in the case because there is no dispute that the children are qualifying children within the definition section. The learned judge was then referred to the cases Coombe and Coombe and the well-known case of Central London Property Trust Limited and High Trees House Limited, dealing with issues of estoppel.
So what was the date of birth of the child?
The date of birth of the child would have been prior to...
Well, it has to be prior to 1987.
Oh, absolutely, yes.
That's all right.
28th December 1986. Oh, so sorry. The two children, I'm sorry, I'm looking at 1020 and the third paragraph down. The first child, 20th July 1981, child C was born to Mrs. C.
So in any case, it's before the coming into force
Oh, it
of
is.
the Family Law Reform Act
Yes.
1987. That's the point.
Yes. The point we make about this is the estoppel argument doesn't apply in respect to these cases, and this is the penultimate paragraph of 1022. High Trees is the only authority which Mr. Jubb, on behalf of the Child Support Agency, has been able to adduce in support of the proposition that estoppel should apply to present circumstances. Estoppel is a remedy in equity. In my judgment, estoppel is to effect justice between parties as to their rights and duties between themselves. But I do not know of any case, Mr. Jubb has not been able to produce one, in which the equitable remedy of estoppel has had the effect of conferring a particular status upon individuals such as these two children. Further, I do not know of any case in which the doctrine of estoppel can affect the rights and duties of the third party, for example, the biological father in this case. Estoppel is not, in my judgment, a doctrine which governs status. And then at 1023, in the second paragraph, in my judgment, a father is a parent if he is either the biological father or becomes the father by operation of law. And we say, in this particular case, the issue found in Latvia would not be sufficient to get within operation of law as properly understood in Jersey. The next of the cases dealing with this is the Re B case, which is MS 754. And this was another decision of Mrs. Justice Bracewell. Where the parties had, in July of 1981, the father donated sperm with which mother was inseminated in December 91. At the time of the insemination, the relationship between the mother and the father had ended. Mother subsequently gave birth to twins in August 92. The father accepted that he was the biological father of those twins and was named as the twins' father on their birth certificate. In July 95, the mother made an application for financial provision in respect to the children under Schedule 1. And there was then a dispute about whether or not he was the father. And what Mrs. Justice Bracewell held at MS 760 is the significance of the biological fact, not the detail of sexual intercourse or other relationship. And she says, this is exactly halfway down the page at 760, I find that if Parliament had intended to alter or amend general principles as to parenthood, specific enactment would have been made in the 1990 Act. And just pausing there, we make the same point about the Jersey legislation. Particularly, certain gamete donors are specifically excluded from being treated as fathers under Section 28.6. I find fatherhood concerns genetics and the provision of sperm which results in the birth of a child, unless either there is a presumption of legitimacy, which affects the situation, or there is statutory intervention, such as, for example, the change of status afforded by adoption or freeing for adoption. I do not find an act of sexual intercourse as a prerequisite to fatherhood, because manual introduction of sperm into the cervix has long been recognised as a possible, though rare, means of conception, which has not prevented the donor being a father. And then a blood test or DNA test to establish paternity does not require additional proof of sexual intercourse. The statute declaration signed by the respondent is prima facie proof of fatherhood. Interesting use of prima facie there, again suggesting not necessarily determinative. The father is the father of the twins. The more significant case still is the T and B case, which occupied a great deal of time in the Jersey courts in considering this matter, and it is a fundamental case in looking at the resolution of this matter. And that is found in MS 1224. The case begins at 1209 and is a decision of Miss Justice Moylan, as he then was. This case concerned two parties, T and B, who lived together in a same-sex relationship but did not enter into either civil partnership or a same-sex marriage. They applied together for T to be artificially inseminated, and as a result, T gave birth to a child. Relationship then broke down. B obtained parental responsibility for the child, and by virtue of there being a shared residence order. T then sought financial provision against B on the basis that B was a parent of the child within paragraph 1, which for all intents and purposes is the same here. In that case, Miss Justice Moylan, as he then was, conducted a very thorough review of the authorities, which begins at 1215, and in particular, he quotes at paragraph 29 the references which we quote in our case from the Ampthill Peerage case. In paragraph 29, which is at MS 1217, he says, in re R, a child, IVF paternity child, the House of Lords considered the effect of the Human Fertilisation Embryology Act 1990. The decision emphasised the importance attached to status, including parentage. Lord Hope of Craighead said at paragraphs 5 to 6, the law has always attached a special significance to a person's status. He then quoted Lord Wilberforce in the Ampthill Peerage. 6. Lord Wilberforce was describing there the status of legitimacy under... sorry, just pausing. That's a quotation we put... The Ampthill Peerage quotation is the one we put in our case. Lord Wilberforce was describing there the status of legitimacy under the then current law in the context of a disputed peerage claim. But a similar view with appropriate modifications may be taken of the significance of the status of parentage in view of the legal consequences that flow from that relationship. The conferring of the status of father on a man who is not related to the child by blood or by marriage to the child's mother is a very serious matter. Lord Walker of Gestingthorpe, with whom the rest of the House agreed, expressed concern about the code of practice produced by the Human Fertilisation Embryology Authority, given at paragraph 35, if an unmarried man is to become the legal father of a child of which he is not the biological father, that is a momentous matter for both father and child. And again, pausing there, we say that is what's happened in Jersey and without parliamentary intervention. He considered at paragraph 26 that more reliable safeguards are needed in the matter directly affecting a child's parentage.
Of course, that's exactly what happened in the Ampthill Peerage case.
In the Ampthill Peerage case, which which we can turn to, which is 1227. So it's in fact the next case there. The court accepted that fraud could be a basis for reviewing a question of parentage, although on the facts of that case,
They didn't.
They didn't, because they said that former lady's note, it's a 127, MS 127, where Lord Simon deals with the possibility of fraud impeaching. In fact, to be fair, it begins at 1270, where it said that fraud would enable the impeaching of parentage. And then he goes on to say that the evidence in support of that was very weak, and Your Ladyship doubtless recalls the evidence was extremely weak, all to do with whether or not sexual intercourse had been completed and so on.
But there had been a determination.
There had been a determination which could have been impeached had there been some evidence of fraud, such as would have been available in the Ampthill case if, for example, all the parties agreed, no, this person is most definitely not the biological child. Or better still, if there had been a direction by a court requiring DNA tests, and the DNA tests had shown the same. What Lord Simon was saying there at 1271 was, to impeach a judgment on the ground of fraud, it must be proved that the court was deceived into giving the impugned judgment by means of a false case, known to be false or not believed to be true, or made recklessly without any knowledge on the subject. No doubt suppression of the truth may sometimes amount to suggestion of the false. But short of this, lack of frankness or an ulterior or oblique or indirect motive is insufficient. And then they went on to deal with cases involving issues of conjecture and so on. Returning to the T&B case, and of course Mr. Justice Moylan had very much in mind the Ampthill Peerage case when he was giving this decision. At 1224, he deals with his conclusions, we say, having conducted that exhaustive review of the law. It is clear to me that respondent is a parent of the child in this case, in the third way identified by Your Ladyship in Re G children resident same-sex partner, namely as a social and psychological parent. She is a social and psychological parent as a result of her relationship with the child and the child's relationship with her. However, as Baroness Hale also notes, there is a difference between a natural parent, as defined by her, and a legal parent. The question I have to answer is whether, as a matter of statutory interpretation, a parent against whom an order for financial provision for a child can be made under Schedule 1 is A, confined to legal parents, i.e., biological parents and those who have become a parent by operation of law, such as by adoption, under the Human Fertilisation and Embryology Act 1990, or under the HFEA 2008, and those otherwise included by paragraph 16, that's 16 of the Act, or B, whether it extends, as submitted by Mr. Goldring, to include any person who has acquired parental responsibility by virtue of an order, or who is a social and psychological parent, a natural parent, as described by Baroness Hale in the Re G case. And it says there are clearly advantages in each outcome. Then at paragraph 57, I've come to the clear conclusion that those against whom orders can be made under Schedule 1 are confined to those who are a parent in the legal meaning of that word. And just pausing at that moment. So if the Latvian courts issue a estoppel, let's put aside the contentious word of parent for a moment, because it may well be that they're using it in a context which is not understood in Jersey. Let's look at the factual matrix, because it's the factual matrix which gives rise to an issue estoppel. If they have found that this non-biological parent, as they find it, a man who is in a non-biological relationship with the child, a man who is not married to the mother, a man who has not adopted the child, a man who has not been the subject of a parenting order under any of the HFEA legislation, if that's the fact they found, the Jersey court did not have jurisdiction and should not have proceeded. Continuing paragraph 57, Ms. Justice Moreland, I've come to that conclusion because, in my view, as a matter of statutory interpretation, Schedule 1 is confined to those who have the status of parent, as expressly extended by paragraph 16, which is the marital situation, not the situation here. It is not, in my view, a discretionary, welfare-informed decision. And again, pausing there, that is a point of contradistinction with Latvia, again, as submitted by Mr. Goldring, but a matter of status. I've been persuaded that this is the correct interpretation, largely because I've been persuaded that Mr. Hyde's submissions are correct. First, I'm not aware of, and I've not been referred to, any criticism of the decision of J&J, which was referred to by Sir Mark Potter in Re A, and which clearly supports the respondent's case. I accept Mr. Goldring's submission that there have been significant social advances since 1992, but these do not, in my view, undermine the effect of this decision. The attribution of legal parentage has not changed since 1992, save as a result of statutory reform. Secondly, whilst Mr. Goldring can rely on references to the meaning of the word parent changing according to the context, in the context of jurisdiction under the Children Act 1989, named under Section 10, it has been decided that parent means biological parent, or other persons who are parents by operation of law. Of course, he's defined that earlier. This is the clear effect of in Re A, and although a passing reference is supported by Baroness Hale's comments in Re G Children, resident same-sex partner 2006 1 WLR 2305 paragraph 11, the applicant in Re G was in the same factual position as the respondent in the present case, but, per Baroness Hale, she required leave to apply for a Section 8 order, which she would not have done if she was a parent by virtue of Section 10.4. And he then goes on to say, at 60, in my judgment, the interpretation of parent in Section 10 gives a better guide to the likely meaning of parent in Schedule 1, a broader analysis in the meaning of natural parent given by Baroness Hale when considering the issue in the context of welfare. I agree with Ms. Goldring that in some contexts it is appropriate to give the word parent a broader definition and include a social and psychological parent. But in my view, Schedule 1 is not using the word parent in a broad, welfare-informed sense, but is confined to legal parent. I agree with Ms. Justice Bracewell when she said in Re B Parentage that if Parliament had intended to alter or amend the general principles of parenthood, specific enactment would have been made. This conclusion is supported by the approach taken by the Court of Appeal to the determination of the issue of parenthood in J and C. The issue was determined by reference to the statutes which define parenthood in the context of artificial insemination by donor, not by broad factual analysis, as proposed by Mr. Goldring in the present case. In order to determine whether the applicant was a parent for the purpose of Section 10 of the Children Act, 1989, Lord Justice Wall, at paragraph 18, determined whether he was within the relevant statutory definition of parent as contained in the two Acts of Parliament, which define parenthood in the context of AID. In my view, I should apply the same approach to the determination of whether the respondent in this case is a parent within the meaning of Schedule 1. Adopting this approach is not contended that the respondent is a parent. And then he goes on to hold that that conclusion is also supported by the structure of Schedule 1, in that if Mr. Goldring's submissions were correct, a person could be a parent by the application of his extended definition, as well as by application of the extended definition within paragraph 16. And the former would make the latter unnecessary, but it also caused potential difficulties in the application of paragraph 2 of Schedule 1, which extended definition does not apply. And he then goes on to deal in paragraph 63 onwards with a situation where someone has obtained parental responsibility, and in the fifth line down at paragraph 63 he says, this might appear a persuasive point, save for the fact that the mere obtaining of parental responsibility is clearly not intended to make someone a legal parent when they would not otherwise be such, as identified in Re C, Minors Adoption Residence Order. Parents with a parental responsibility are a subset of parents, and as stated in Re A, a person who acquires parental responsibility does not thereby become a parent. Otherwise, many people, I've already given the example of grandparents, would become a parent when plainly they are not. Although I do not see how the doctrine of estoppel can assist the applicant. To adapt Ms. Justice Bracewell's conclusion in Re M, a person is a parent if they're either a biological parent or if they've become a parent by operation of law. Someone acquiring parental responsibility does not thereby become a parent. The doctrine of estoppel cannot, in my view, assist the applicant to procure this result on the same factual basis by an alternative route. The position is further emphasised by the comments in the Morgan and Hill case, which was a case where the mother had children by different fathers, and she chose to pursue one of those, and it's just a short reference there at which is in MS 1046.
How are you doing, Mr. Todd? You've only got 10 minutes left.
I'm very conscious of that, my lady. I will finish in those 10 minutes.
I just thought I'd better give you a 10-minute warning.
I'm very grateful. Thank you.
So what's the page reference to Morgan and Hill?
My lady, it is... well, I'm going to skip 1046, which is what I said, and go straight to 1050. 1050, which is from the judgment of Lord Justice Hughes. He agreed with Lord Justice Thorpe, who gave the main decision, but he summarised very shortly at paragraph 65, there is simply no jurisdiction to order this father to support Mary. That was a social or psychological, a person who might be a social or psychological parent but was not a biological father, was not a parent who was married to a mother. It seems to me the judge fixed the new payroll payments correctly by reference to the needs of Mark. And then 4 lines down, what is not permitted is any order which does have the effect of fixing some of the responsibility for Mary, not his biological child, onto him, and this is so whether or not her own father is making proper provision for her or is in a position to do so. That case is also interesting for a potential problem that arises post the Jersey Court, which is the multiplicity of people who could be pursued in order to provide for this child's maintenance. There is the gentleman still in Latvia, who we believe is the biological father. There is, of course, also the respondent's new husband. They are both susceptible. It's not going to be the case that this child is left without any support from people who are either his biological father or married to his biological mother. We've referred very briefly, and perhaps if I can just give the reference that we would have had to the Valentine case, the reference would have been MS 1139. And in the Luck case, our reference is at MS 1571. But those are matters which fall to be considered in the more comprehensive, we say, decision of the case of Roe, which is at MS 1142. And it was that case which we say very comprehensively dealt with many of those issues which are now raised by my learned friends. And just pausing at that moment, if my lady and my lords have the time, we would invite you to read again the skeleton argument that was put forward on behalf of the appellant in the Court of Appeal in Jersey, because that addressed the issue of estoppel point head-on, as indeed we do in our case. But it was more focused on it for the simple reason that at that time it was still a substantial argument. In the Court of Appeal in Jersey, they felt it unnecessary to go into the detail of the issue of estoppel point, and it's really because they felt it unnecessary to go into it that we concentrated our focus more on what is apparent and whether or not there is a legal extension of it.
I'm surprised you say the Roe case is analogous. I think I was in it. I think 40 years ago, I was almost to the day, I was addressing the Court of Appeal. It was it not? Shows how long in the tooth I am, Mr. But was it not a case where, do you want to be heard on custody? No, custody order made. And then he was disabled from saying, well, I never treated this child as a child of the family. And the answer was, I'm so sorry, there's a custody order here. And that can only be made in respect of a child of the family. And the judge said, well, you're stopped, I'm afraid, from disputing that you accepted straight treated the child as a child of the family. And the Court of Appeal said, no, 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 no. So it's very, very different, isn't it?
It's one of those examples. It's not very, very different with respect to Samuel Lord. We would say it is an illustration of there being exceptions in the right case to what would otherwise be an absolute rule. What I think my learned friends are arguing is that there is an analogy here with a decree absolute. It is a point of absolute certainty. Well, leaving aside our arguments as to why even a decree absolute could be attacked in circumstances such as this, including the public policy grounds that we set out in our case. Here, we say this is an illustration of where there was a particularly hard case, of where the court was able to say, well, actually, we're not having to simply say that there's a Henderson-type issue of estoppel and that we must be held to it irrespective.
Can you just help me on this basic point? The courts now seldom have to decide for themselves about paternity. DNA tests resolve these issues. But in the Latvian case, they weren't available. I think back to when I was a young family lawyer doing affiliation cases, and I might be representing a man who was accused to be the father of the mother's child. And we would argue before the magistrates that we were not the father of the child, and the magistrates held that my submissions were wrong, and I was the father of the child. And then I would appeal, I think it was to Court of Sessions, Crown Court. I would exhaust all my appeal rights, and the result remained the same. You have been established to be the father of the child and must pay maintenance. There would be no point my having exhausted all my appeal rights in my saying year after year after year, I'm sorry, this is based on a complete falsehood. I'm not the father of the child. There comes a time, doesn't there, Mr. Todd, when the courts say it's been determined. And is this not a case where the Jersey court has said, in Latvia, with jurisdiction, it's been determined when you were first asked to provide maintenance in Jersey for the child, you rushed off to Latvia and sought to get the declaration of parentage scrubbed. And that took 2 or 3 years. And the Jersey courts the Jersey jurisdiction remained in abeyance, and you failed. And so then the Jersey financial proceedings continued. There comes a time when the justice system says, I'm terribly sorry, it's been sorted. Is that not the case here?
It's not the case here, my lord. And the affiliation proceedings are a very good illustration of how it is that the res judicata does not come down, because, of course, as we all know, in a lot of those affiliation cases, people were subsequently able to find DNA evidence which cast serious doubt on what had been decided previously, and mothers who'd been unable to prove paternity were then able to obtain support. And there are many authorities, and we've included them within these bundles, which say affiliation proceedings don't act as a res judicata, and we say the same would apply here. And here, what's happened is that there has been a change, and the key quasi-judicial determination was the acknowledgement in 2006. And what happened after that was the new evidence that comes into play, certainly on the appellant's case, is the declaration by the mother that he is not the father. So to take the example of your affiliation case, if your lordship's advocacy has not succeeded and you've gone to the Crown Court and they have refused your appeal, and then the mother comes along and says, okay, I accept you're not the father, you can't possibly have been the father, and I'm prepared to join with you in evidence in saying you are not the biological father. Then at that stage you're not held to a res judicata and the court must conduct a review.
But the problem about that is that in the Latvian proceedings in 2011 and 2012, the mother was saying that your client was not the natural father. All that was factored in.
Right, and that's where I was just coming to with your lordship. So in that situation, your lordship goes back to the court, and the court then says, well, it was something that you could have worked out for yourself then, and therefore you shouldn't really be reviewing it. And that is the extent of what the Latvian court did. And there are really two aspects of what the Latvian court did which should have troubled the Jersey courts. The first one is they didn't conduct that review in the light of the 2006 order being so seriously impugned. And they didn't do it solely because of a 2-year limitation period, something which would be offensive to English law when it comes to affiliation proceedings. And second, we come back to what was the issue they actually determined? Because they did not determine, and this cannot be emphasized strongly enough, and I make it in my last few seconds, they did not determine that this man was a parent for the purposes of the Jersey legislation. What they determined was that he was a parent for the Latvian legislation. And they're not the same thing. And we know they're not the same thing because they incorporate all different criteria and so on. So the issue that they determined, which we accept this court has to follow, is that he was not the biological father. And that, in terms of pure fact, as opposed to putting labels on things, is the extent to which they went. And then the Jersey court, looking at the fact of that he is not the biological father, then had to apply the facts which have been decided, the issue estoppel which arose from Latvia, to the particular statutory scheme which they had to apply in Jersey. My lady, my lords, I notice time. I don't know if I can assist your ladyship or my lords any further.
I think we put quite a lot of stuff to you, Mr. Todd. Thank you very much indeed. Mr. Cullen?
My lady, my lords, may I begin by restating what we say the issue is in this appeal. We say that the issue that this court is considering is whether the term parent, set out in Schedule 1 of the Children Jersey law, includes both the legal parent and the biological parent, accepting that those two may not be the same. In particular, we say that this board...
And also somebody who's treated the child as a child of the family, a step-parent who's treated the child as a child of the family. So there are three possible ones.
In particular, we say that this board is asked to determine whether the Jersey Court of Appeal was correct to include the appellant as a parent under Jersey law based on his acquisition of that legal status in Latvia. And of course, he acquired that legal status in Latvia as a consequence of his own voluntary acknowledgement of legal parentage. We say that the Jersey Court, in concluding that the appellant was a parent by operation of law, gave recognition to the decision of the Latvian court as to parentage. And we say that that approach by the Jersey Court was permissible, that it was lawful, and that it was consistent with wider public policy imperatives which underpin Schedule 1 of Children Jersey law. We're aware that the court, of course, has read our written case, and the detail of the discussions between Mr. Todd and the court have indicated that there are many of the matters that we put in our written case have been picked up by the court in those questions. So in our oral argument, we would like to address the court on 4 points. The first point that we will focus on is that the Jersey statute itself is sufficiently broad to permit the recognition of both biological parentage and those who acquire parentage by operation of law. If this court, or the Jersey court, was to limit parent in Schedule 1 to biology, we say that would be overly restrictive, and that would be contrary to the objects and purposes of Schedule 1. The second point that we would like to address the court on is the divergence of approaches to establishing and disestablishing paternity internationally. Make it clear that there is a lack of consensus as to the primacy of biology. And we would like to review briefly with the court decisions of other jurisdictions, including England and Wales, but also of the European Court of Human Rights. And we say that a review of those authorities demonstrates that the decision of the Jersey Court was both permissible, but also compliant with convention obligations. The third point, which we would wish to address the court on in further detail, is that a decision as to parentage is a decision as to status, and it is as such a decision in rem. And as a matter of private international law, we say that the Jersey court was entitled and indeed obliged to give effect to it. And the last point that we would wish to address the court on, propose addressing the court on, relates to public policy grounds which underpin recognition of status decisions. May I, before going on to each of those points, begin by revisiting very briefly some of the facts on which you have been addressed this morning by Mr. Todd. And I would also, before dealing with those 4 points, like to revisit the decisions of the Latvian court. It's central to the appellant's case that he was a victim of a fraud. We say that that is incorrect, and we say that it has been determined by the Latvian court as being incorrect. We say also, when we review the decision of the Latvian court and the applications which have been made to the Latvian court, and indeed to the courts in Jersey, that the appellant's case is wholly contradictory in relation to the facts on which he relies. And that, we say, is a significant factor that this court has to take into account, and it was a significant factor taken into account by the Jersey court. This child has been the subject of 4 different applications in Latvia. The appellant has been the applicant on each occasion. 2 of those applications go to parentage, and 2 of those applications go to the exercise of parental responsibility. May I deal with the first 2 applications, and those are the application in 2006, which was a joint application by the appellant and the respondent. And you'll find that, and you've looked at it with Mr. Todd, at MS 133. And that application, as we've already established, is an application under Article 155 of the Latvian Code for an acknowledgement of paternity. So it is Record of Proceedings, Part 2, forgive me, Part 1, page 133. And there are 2 points that we would make about this application. First of all, it is not an application, per se, to be recognised as the biological parent of this child. Although within the application, an assertion is made by Mr. C that he is the biological parent, that is not the application which he makes. If one then goes on to look at the statement which accompanied that application, and again, the board has looked at that already with Mr. Todd, it is at MS 178, that reiterates a number of key points. Again, the application is to be acknowledged as a parent. A second important point is that that application is made with the consent of the mother. Then you see at MS 179 the assertion made by the appellant as to biological parenthood. Now,
on that page, am I right in thinking that there was a parallel application by, I'll call him RZ? I'm looking at number paragraph 1 at the bottom of 170.
it would appear that the application that was being made was an application to remove RZ from the birth certificate. And
Consented to, at least.
indeed. And to determine the paternity, we see at point 2, I asked the Honourable Court as the beginning, and then annulling the current record and conferring the appellant's name as the family name. So it is a re-registration application arising as a consequence of a voluntary acknowledgement of paternity. That application, we say, then needs to be read with the second application made to the Latvian courts, and that is the 2011 application. And the second application, again, the court has looked at this, is at page 323. The decision of the court is at page 323. The application is made, as my Lord Wilson noted earlier, within the currency of the Jersey proceedings, and it is an application to set aside the 2006 parentage declaration. There are a number of parts of this judgment that we would like to draw to this board's attention. First of all, it is incorrect to say that the court determined this matter on the basis of submissions alone. The court had the benefit of written evidence, but also the court heard oral evidence. And we see that from page 325, second paragraph, having listened to the explanations of the participants in the case, the testimonies of the witnesses during the sitting of the court. It is our understanding that the appellant chose not to give evidence, but that the court heard from the respondent and a number of other witnesses as to disputed facts in the case. That, of course, is important as to process, but it's also important as to the substantive findings which were made by the Latvian court. A second point that I would like to draw to the Court's attention relates to the legislative framework in Latvia within which the decision, or the application first, and then the decision was being made. If we look at the bottom of page 325, we see that the paragraph, fourth paragraph up begins, the plaintiff has raised the claim on the acknowledgement of the entry of the father as invalid since the day it was made. The Court then goes on to set out what the basis of an application is to the Latvian court. The Court may acknowledge the recognition as null and void only if a person who has acknowledged that a child is his, that being the situation here, cannot be the natural father, and he has acknowledged the child as a result of mistake, fraud, or duress. And then it goes on to refer to the 2-year time limit in the same paragraph. It's helpful then to look over the page at how the Court explores that issue further before making its substantive decision. At the top of page 326, the Latvian Court observes, there is a cognition consolidated in the legal literature that the basis for the acknowledgement of paternity as invalid is the simultaneous existence of 2 mandatory criteria. The first is that the person who has acknowledged the child as one's own cannot be the child's blood father, so the biology point. But the second, and it's the simultaneous existence of these, is that the person who has acknowledged the child as one's own did so as the result of delusion, guile, or coercion. Now that may be a translation modification, because of course on the previous page the reference was to mistake, fraud, or duress. But the point that we would make to this court, and the point that was given some weight by the Jersey court when looking at the recognition of this decision, is that it is the 2 elements of section 156 which need to be present. So one is biology, and the second is that the person making the application, that being in this case the appellant, must prove the factors set out in paragraph 2, that there is delusion, guile, or coercion, or duress, mistake, or fraud. And those 2 matters are fundamental because the appellant's case fails in relation to both, notwithstanding the fact that it was common ground before the Latvian court that he was not the biological father. You can see also at the bottom of page 326 the reference to the common position of the parties. There is no argument between the parties that the plaintiff is not the biological father of the unmarried child.
It's hardly surprising that mere agreement by the 2 parties doesn't amount to proof. Could not be the father because they could be wrong.
No, well, in the context of an application which seeks to resolve from evidence given in 2006, I accept that observation by the court may not carry too much weight in the absence of scientific evidence. But the submission that we would make to the court is, even if he had been able to establish that he was not the biological father, which he wasn't and didn't, the Section 156, according to the Latvian court determining the issue, requires 2 different mandatory criteria to be simultaneously satisfied. In other words, it wouldn't be sufficient that he would also have to demonstrate as a matter of evidence that he had been, as he puts it, a victim of a fraud. That second point, of course, the court has previously looked at the determination of the Latvian court on that second point. He was unable to satisfy the Latvian court that he had been the victim of a fraud. And I had a moment ago taken the court to the fact that evidence was heard in the proceedings. There's no procedural defect in the Latvian process. The appellant chose to present his case without giving evidence. Nonetheless, the court went on to consider the written evidence that he had given and reached the conclusion that he hadn't made out that ground. And that is fundamentally important to our case and fundamentally important to the approach taken by the Jersey court, because the appellant repeatedly revisits and asserts something which the Latvian court has dealt with and determined. It's also important to have regard to the fact that at no point in the proceedings, either in Latvia or in Jersey, has the appellant provided any evidence as to the nature of the fraud which he says was perpetrated on him. And that was quite an important factor, it seems to us, in persuading the Latvian court that he did not satisfy the burden of proof in relation to that. So in looking at the decision of the Latvian court in 2012, we say that it underscores a number of key points in relation to Latvian law. And the first point is that it's central to the decision that paternity, and therefore legal parentage in Latvia, can be established merely by voluntary acknowledgement. We say it also emerges from the Latvian decision that there are strong public policy arguments which were considered by the Latvian court in its determination, driven by best interests of the child, for placing a time limit on revisiting the issue, the 2-year time limit, but also for requiring a person who makes a voluntary acknowledgement to be limited in terms of the circumstances in which they can set that aside, if the motivation for setting it aside is the breakdown of the relationship with the mother. And it's clear from the Latvian decision that the stability of the child, the security of the child, were part of the best interests adjudication. And that, in our submission, is consistent with the Latvian law and is consistent with the decision of the, or emerges from the decision of the Latvian court as to it being unacceptable for somebody in the position of the appellant who voluntarily acknowledged paternity to come back to revisit that some 5 years later without any evidence to justify why the original acknowledgement of parentage was made in the first place. May I move on then to look at the two remaining, or to draw the court's attention to the two remaining Latvian applications. The third application, which was made by the appellant, and this is at MS 189, was a custody claim. And that claim was made in 2014.
It's called a counterclaim, and I was trying to work out to what claim was it counter. What's the answer to that, please, Ms. Fottrell?
I'm not entirely sure. May I check that over
Very well.
adjournment?
Thank you.
What was the page reference? I'm
Which
sorry.
is MS 189.
Thank you.
Now, it's clear from that application that the appellant was seeking custody of the child. And we see at page 189, just above the paragraph heading Factual Circumstances, the defendant asks to establish the separate custody of him for his son.
Sorry, just on the counterclaim point, I think in the first paragraph it said that the mother has brought a claim.
Yes, I see that. Thank you.
Herself.
Yes, thank you. For custody.
Yes, thank you.
If we turn over the page at page 190, the paragraph that begins A4, there is the appellant's assertion within those proceedings, and that is after the decision of the Latvian court in 2012 the defendant, who does not have any other children, has achieved through the court the recognition of paternity, regardless of the fact that the child has originated from another man during the relationship existing between the plaintiff and the defendant. And then at the bottom of the page, page 190, is a paragraph explaining why the defendant made his application to set aside the acknowledgement of paternity, where he says he did it for the purpose not that he did not deem the child as his child, but due to the fact that he understood the actual purpose of the plaintiff's attitude towards the defendant. And it goes on to make a number of assertions about the attitude of the respondent towards the appellant as he saw it.
So sorry, where were you just reading from?
The last paragraph on page 190, MS 190, and up to the beginning of page 191. Of course, what emerges from that is that the appellant was willing and able to act on his legal parentage. One of his motivations for doing so, it would appear from this application, was as a consequence of the breakup of his relationship with the mother. And there's a punitive dimension, we would say, or punitive tone to the application, seeking on the one hand to assert parentage, and on the other to deny it. And then the last application made within the same year is the fourth application, which is an application under the Hague Convention on child abduction, which is at MS 246. That application we see is made on the 29th of May 2015. At this point in time, the respondent had left the jurisdiction of Latvia with the child, and the appellant, in reliance on his legal parentage in Latvia, made an application under the Hague Convention on Child Abduction for the return of the child to Latvia.
I'm just trying to understand why this issue about custody had blown up, Ms. Fottrell, we don't quite know when your client issued her custody claim. I wonder whether it had blown up soon after the order in Jersey for maintenance to be paid at a substantial rate by the appellant here to the respondent.
Yes. My lord, I think the timing of that is probably, the coincidence in the timing is probably correct. Perhaps I can clarify that over the adjournment and address my lord on it.
So within 3 months of his having been ordered to make substantial periodical payments for the child, he was saying to the Latvian court, the child should live with me.
Yes.
Yes, very well.
And then the application at 245, he was saying to the court the child should be returned to...
Well, quite, yes.
So, my lady and my lords, what we say is that although the appellant repeatedly asserts that he erroneously, voluntarily acknowledged this child as his own, owing to a fraud perpetrated on him, within the Latvian proceedings that issue was resolved, and the Latvian court said that he did not erroneously acknowledge the paternity. But it's also relevant that at no point was the Latvian court determining the biological parentage of the child. And lastly, the appellant has been willing to act in reliance on his legal parentage, and indeed the decision of the Latvian court in 2012 as to the validity of his legal parentage in launching custody and child abduction applications.
But in what way does that actually help us to resolve the issues before us?
Well, my lord, it's part of the background. I want to go on, if I may, to look at the 4 points I identified at the outset. But we say it speaks to the contradictions and the inconsistencies in the appellant's factual case and indeed his legal case, that in one jurisdiction he's seeking to renege on his legal parentage, querying and seeking to undermine its validity, and in another jurisdiction he's accepting a substantive decision as to the validity of his acknowledgement of parentage and seeking to act on that. We say that is relevant in terms of the broader canvas, factually. It's not germane to the issue of whether he is a legal parent or not, but it is a part of, we say, the factual background. My lady, my lords, that may be a convenient time. If I may, after the adjournment, I would like to begin by addressing the court on the interpretation of Article 1, Schedule 1.
Yes. Well, the board will now adjourn and return.